But first, let's get started with a roundup of today's top crime stories.
Here are today's top crime stories trending on Law&Crime.com and across the country. A man in Columbus, Ohio was arrested after he reportedly ran over his own child twice with his car while texting. 24-year-old Trenton Cook allegedly ran over his 22-month-old son, Zakai, when he pulled into the driveway of his home and reportedly backed up over the child before realizing he was there. Authorities believe Cook was texting at the time of the accident. Cook is facing charges of second-degree homicide by vehicle and failing to exercise due care. The man captured on video viciously kicking a cat outside of a gas station in Atlanta is now in police custody. 22-year-old Jamari Davenport turned himself in to police after video of the incident made the rounds on social media. The cat has yet to be found, and authorities are unsure of the injuries the feline sustained. Davenport faces a charge of misdemeanor cruelty to animals. Disgraced Hollywood producer Harvey Weinstein wants his rape indictment in New York tossed out and says he has emails to prove his alleged rape victim consented to sex. Weinstein is accused by 80 women, including A-list actresses, of sexual misconduct. The allegations against Weinstein helped launch the hashtag #MeToo movement on social media, encouraging victims to tell their stories of sexual harassment and abuse. Weinstein is also under investigation in Los Angeles and London for alleged sex crimes. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Thanks so much for that, Anthony. Well, I am live in studio this morning with Michael Bachner, criminal defense attorney. Thanks so much for being with us, Michael. Let's talk about this Harvey Weinstein story because it's a bit of a twist here. There is a case going on in Delaware having to do with the bankruptcy of his company where these emails come out from one of Weinstein's accusers, and now his attorney Ben Bramfman wants to argue to the New York judge the whole case should be tossed. First of all, it was surprising to me that these emails that would be so important in the sex abuse case come out in a bankruptcy hearing. How does that happen?
Well, obviously something occurred during the bankruptcy litigation that required these emails either to be disclosed during the course of discovery or that they may have been voluntarily disclosed for some reason. What Ben is trying to do, Bramfman is trying to do, is he is arguing that the grand jury presentation was defective due to prosecutorial misconduct. And that misconduct was by knowingly withholding from the grand jury evidence which tended to exculpate Weinstein. That is, evidence which tended to show that he was not guilty. The standard in New York for the presentation of exculpatory evidence in the grand jury is not a good one for the defense. The prosecutor has no obligation to affirmatively present to the grand jury evidence that a defendant is not guilty, but what he can't do is mislead the grand jury. So if he presented evidence from this victim that something occurred and he had emails demonstrating that she was not being truthful, that could be a big problem for the prosecution.
Well, we don't know exactly what those emails say yet, but from what I am reading online and from what Bramfman has been telling the court, these emails are from one of his accusers in the years after she alleges the sexual assault happened. And he says that they show a close relationship, a friendly relationship. It's not clear that they're necessarily saying, you didn't do this to me. I mean, I've been reading articles, well, just because the victim stayed in touch with him, you know, this is the Hollywood business. She may have just wanted to keep on his good side, didn't want to lose roles, fear. The emails may not necessarily be exculpatory, as Bramfman is saying, right? Completely
correct. And I don't know if Ben actually has those emails yet, but you're right. If the emails go directly contrary to what she said occurred on that evening, for example. So if she had sent an email saying, had a lovely time with you, that would be clearly exculpatory. But I agree with you. The mere fact that she may have had an ongoing relationship with Weinstein subsequent to the event didn't mean that the event occurred. It certainly goes to potentially directly to her credibility, to the extent that she maintained a friendly relationship with him, right, rather than a business one.
Yeah, the legal team says that the emails present a picture of a woman who was showing affection for him. What do you think, knowing what you know about Ben Bramfman, about this case, about the judge, do you think it will work in getting the charges thrown out in this case?
Well, in full disclosure, as you and I discussed, I was Ben's first associate back in 1980 to 84, so I know Ben very, very well. As aggressive and as good a lawyer it's very hard to find in the country. I can tell you that Judge Burke, presently who's in charge of the case, is also a former prosecutor in the Manhattan DA's office. His reputation is being very careful, but also he's considered to be one of those judges who's a little more on the prosecutorial bent. So I think to the extent that the law is either ambiguous on a point or can go the prosecutor's way, that's the way it's going to go. Additionally, the law is very clear in New York that there is a presumption of regularity in the grand jury. And when a grand jury votes an indictment, it's not something a judge should very easily dismiss. So the standard on this exculpatory evidence is going to be whether the grand jury was misled. And candidly speaking, even if the judge would have ruled that they were, I think they would still give the prosecutor the right to represent to the grand jury. So it's not.
Yeah, and let's be sure to note that these emails only relate to one woman.
Correct.
And Weinstein is facing charges for assaults related to 2 other women as well. Now, if the judge says, you know what, I'm not going to toss the indictment, we're going to move forward, will these emails be allowed to be introduced as evidence at least? I mean, is that getting too far ahead of us at this point?
I think the chances of the emails being presented as evidence are very, very good. The whole theory of the defense is going to be that this was a woman who was not a victim, but that she had a knowing, consensual relationship with Weinstein. And it's a very fair argument to make to a jury if, in fact, you were the victim of a forcible sexual assault. Are you going to maintain a loving, affectionate relationship, depending on what these emails say? So I don't know what they're saying, so we're jumping a little ahead. But if the characterization from the defense is accurate, I cannot see a judge not letting those emails in.
Well, it will certainly be interesting to see how this unfolds, and we know this case continues to unfold. I'm sure Brenfman and the entire legal team is really looking for anything that they can find to get him off on at least some of these charges.
I can assure you, knowing how Ben runs a criminal case, that there are investigators investigating every single angle of every single victim. In this case, alleged victim in this case.
And Weinstein maintains his innocence in all of this, as
Absolutely.
all of these relationships were consensual. So we will, of course, be continuing to keep an eye on all of the developments related to Harvey Weinstein. But now I want to move to another case that we have been covering this week out of New Hampshire. In case you missed it yesterday, we had a verdict in the assault case against Jordan Lamond. Remember, he is the man who followed a woman out of her job at a Planet Fitness and beat her in the head some 40 times. It was caught on surveillance video. That video went viral. It led to police arresting him. He was on trial, facing charges of second-degree aggravated assault. So, did the prosecution prove their case? The defense had argued, look, this should not rise to that level of a felony because she survived. Not only did she survive, she walked away. So let's go ahead and replay the verdict, and then we'll come back and discuss.
Would the foreperson please rise? The clerk will give the jury's verdict.
Sir, as to docket number 219-2017, CR 547, charge ID number 139-4061C, charging Jordan Lamond with second-degree assault, how does the jury find the defendant guilty or not guilty?
Guilty.
So say you all? Yes. Okay. As to the same docket number, charge ID number 1503678C, charging Jordan Lamond with simple assault, alleging kneeing Aaron McCarthy in the face, how does the jury find the defendant guilty or not guilty?
Guilty.
So say you all?
Yes.
And as to the same docket number, charge ID number 1503679C, charging Jordan Lamond with simple assault, alleging grabbing Aaron McCarthy and throwing her to the ground, how does the jury find the defendant guilty or not guilty?
Guilty.
So say you all?
Yes.
And as to the same docket number, charge ID number 1503680C, charging Jordan Lamond with simple assault, alleging punching Aaron McCarthy with his hand in her face area, how does the jury find the defendant guilty or not guilty?
Guilty.
So say you all?
Yes.
Thank you. Please be seated.
Thank you, sir. Durkin, do you wish to have the jury individually polled on any of the verdicts? No, Your Honor. Ladies and gentlemen, thank you for your service in the case. If I could ask you when you retire to the deliberation room to just wait a few moments so that I can personally thank you for your service to the county. Thank you. All rise. Jury.
Welcome back. Well, there you have it. Jordan Lamont guilty of all of the charges against him involving that assault of Erin McCarthy outside the Planet Fitness in Ohio back in 2017. Now, we're going to show you the longer version of the video. Up until now, we only had a short clip, about 30 seconds. But as you may know, if you've been watching us, our own Aaron Keller was up there in New Hampshire following this case, and he obtained the longer video that shows the whole thing as it happened. Pretty brutal to watch. Michael Bachner, criminal defense attorney, with me here in studio. Surprised at all about this verdict?
Not at all. It sounds to me like this is a case in which the defendant probably wasn't offered very much as far as the police concerned, and figured, you know what, might as well take a shot at this. But
it just keeps going and going here. We hadn't seen this whole thing before, and wow, no wonder. It is amazing the woman walked away and did not have any serious injuries. There you see him getting in his car and fleeing. I believe that was a Ford Fusion. She was able to run away. Presumably, she's terrified for her life. Quickly, Michael, it was a second-degree aggravated assault charge. Prosecutors had to prove that he showed blatant regard for whether or not this victim would survive. The defense said it did not rise to that. Obviously, the jury didn't disagree. What do you think about the statutory
The standard
charge?
of serious bodily injury that they had to show the reckless conduct is merely that there was protracted or severe physical injury that could have caused that type of protracted or permanent injury. And hitting someone 45 times and kicking them, etc., that exposes someone to that kind of risk.
She could have, although it didn't come up in trial, but problems down the road. All right, thanks, Michael. We're going to take a quick break. When we come back, much more of all of the trials we are covering today from all over the country. Stay with us. We'll be right back. Welcome back. I'm Stacey Delikat. Thanks so much for being with us this morning. In just a few minutes, we're going to take you live into the Ohio courtroom where it is day 8 of Anthony Kirkland's resentencing trial. Remember, he is facing the death penalty once again for the murder of 2 young girls, the brutal murder of 2 young girls. Kirkland was already sentenced to death for these killings. That's on top of the life sentences he is serving for the murders of 3 other women. But this death sentence was tossed out because of prosecutorial misconduct a few years ago, because of some comments the prosecutor made. Now a new jury will decide whether or not to reinstate the death penalty. Well, yesterday was a kind of interesting day in court because obviously the defense is trying to prove there are mitigating factors here, and they are trying to show that Kirkland has brain damage, that he's troubled, that his brain shows signs of neglect, of abuse. They put up a doctor, Dr. Joseph Wu, several days ago, who you may have seen his testimony if you've been watching us, who said he did find that Kirkland's brain showed signs of severe neglect and abuse and crippled his decision making. Well, the prosecution says not so fast. Not only have they challenged this witness, Dr. Joseph Wu, even asking, is it true that you've been known to be a charlatan in your field? They now presented their own witness in rebuttal, another doctor, Dr. Waxman, who says he looked at the scans and thinks his brain looks perfectly normal. So this was kind of a protracted battle between the doctors that we saw play out almost most of the day yesterday in court. So Michael Bachner still with me here, criminal defense attorney. What do you make of this? I mean, it seems like they're spending a long time going back and forth between these 2 experts. I saw abuse. I see signs of abuse. I don't. And apparently these 2 doctors have gone up against each other in court multiple times.
Well, the defense's job in a death penalty case, where it's the ultimate penalty, the taking of a human life, is to try and get a jury to understand any mitigating factor that they would find compelling enough to say, this guy's a piece of garbage, but giving him a death penalty is just not necessary. So they go to the mitigating factors like the childhood, the background. Now, having a medical issue that could impact on the person's ability to make a decision, not that it's a defense, but that it impacts on the way he acts, a jury can go back and say, the guy couldn't help it, or the guy had to. But these battling experts is extremely common, whether it's in an insanity defense or whether it's in this type of matter. Defense throws up, the issues. Prosecutor tries to knock it down. I hope a bunch of juries go back. 1 or 2 of the jurors say we can't decide. Do
you think the jurors, get sort of put off by that at all when you've got 2 witnesses kind of going back and forth, or you think it is kind of interesting to read about?
You only need 1 juror in a death penalty case to say that I don't buy it. To the extent that they can get 1 of the jurors to say, I think Wu had a point. I don't think this guy should get killed as a result of that defect. It's
right. And Wu has said, over the course of interviews, he determined that the defendant had a bike injury that may have injured his head. Is that different to show you were injured in an accident and suffered a brain injury like that versus if you had a traumatic childhood? Because so many of these cases, right, the defense tries to say he was abused, he, suffered all of this neglect, this is how he was brought up, but is it different if you have like a brain injury from an accident, something like a bike accident? I'm just wondering, is that supposed to be weighed differently because,
I think it's all weighed as part of the package. You can have some type of injury as a result of some horrible thing that you went through as a child, but you can also have an injury that's impacted, purely accidental, that can still impact your ability to make a decision. So I think it's all part of the jury's calculus. You and I were remarking earlier that this case was sent back by the appellate courts because the prosecutor, I don't know if it's the same prosecutor.
It's a different prosecutor.
Different prosecutor. He made remarks, or I think it was a he, made remarks that were really out of line.
Right.
And the court sent it back saying, hey, you're depriving this guy of
He had said if you don't give him death, it'll be like these 2 other murders or freebies for him, because he's already serving the life sentences for the 3 other women. And
that's why I thought that the question, I don't know the exact phraseology, but to say to Dr. Wu, don't people think you're a charlatan? I think that is a really objectionable question to ask. And I could see an appellate court looking at that in a very, very close fashion and saying, that's a bad question.
I agree. I was shocked when I heard that and read that. These experts for both the prosecution and the defense, how does this work? When these guys have been up against each other in court multiple times, is Dr. Wu paid by the defense team?
Yes, or probably by the taxpayer.
Right.
He's probably a court-appointed psychiatrist, and in a death penalty case, one of the arguments against the death penalty is it costs so much money to put someone to death. Is it even worth it?
Right.
It's millions of dollars.
Interesting.
This will get appealed again, and then maybe get sent back again, and then he'll go to the federal court for an appeal. It's an enormous amount of money.
So it's a court-appointed psychiatrist.
Probably.
Are there cases, though, when a defense team, a private defense team, will bring in their own experts, of course?
100%.
And those experts are often paid.
I mean, we saw this, on some levels on the OJ case, where you had the battle of the experts, the blood spatter people, et cetera, and going back and forth, trying to create a reasonable doubt. The defense is trying to do, and the prosecutor's trying to live up to their burden of proof. This is a very common. I have an insanity matter I'm dealing with now. And I can tell you right now, we're having the battle of the psychiatrists.
Right. It happens a lot. Well, thanks for that insight, Michael. While we get ready for court to resume, we do want to go back to some of the highlights we have seen so far in the 7 days of this trial. One of the witnesses that we heard from was Patricia Crawford, and she's the grandmother of one of these young women who was brutally murdered, Cassania Crawford. She recounts the night of the murder, how it all went down. Let's go ahead and take a listen. Well, that was testimony from Howard Grant from the Cincinnati Police Department talking about the discovery of Cassania Crawford's body, the young teenage girl who was killed by Anthony Kirkland in 2006. He said her body was found literally in a junkyard, a trash yard, covered in tires. Her body had been so badly burnt they couldn't visually identify her, and they had to use dental records. Just a brutal, brutal crime. Michael Bachner, criminal defense attorney, still with me here in studio. Now, this is a resentencing hearing, so this isn't a question of whether or not he did it, but this jury still needs to hear all of the details of these crimes because it's a new jury, right? When you hear hear about these sort of gruesome, gory details, how does that sway the jury? I mean, I imagine it sways them against the defendant.
It does, and the purpose is to demonstrate that under the death penalty criteria that you need, that this was one of these really aggravated types of murders as compared to, for example, a single bullet shot, and demonstrates the type of callousness and malice that the defendant exhibited, and it's intended to offset the mitigating type of factors that may be expressed. But a prosecutor has to walk a fine line. You can actually sanitize or actually kind of offset these feelings by putting too much out there. It causes people to you get used to it. And prosecutors should use the evidence. That's why you'll see very few pictures at times. Sometimes the words speak louder than those pictures. But that's the purpose of it. It's completely legitimate. It's necessary to let them know that this defendant exhibited absolutely no humanity in his dealings with this
I mean, it's always, when I hear these cases, okay, they didn't just rape, didn't just murder, leave the lifeless body, but then had to take it a step further. And we were sort of, I was talking about the previous guest, how he had this habit, I guess you could say, of burning his victims' bodies. So truly disturbing stuff, and we'll have to see how it all plays out. Again, if you're just joining us, we're waiting for court to resume in just a couple of minutes, live out of Ohio. The attorneys are in the courtroom. And just as soon as it does, we will take you back there live for day 8 of this resentencing hearing. In the meantime, we're going to take a quick break, but stay with us. Much more to come today. We also have a sentencing coming up live. Stick around. We'll be right back. Lisa Kenny in a pre-recorded deposition talking about the night her daughter Esme Kenny went missing and the really just awful process of searching for and finding her body. Michael Bachner, as you just said, it's just the torment a parent goes through when something like this happens.
Yeah, it's the need really for the jury to understand that it's not just the death, it's what occurred before the death is discovered. I was looking for, we were hunting for all the emotional ups and downs. Can you imagine losing a child and not knowing every day, every minute, where's my kid? Where it's horrible.
And obviously jurors, parents, or, even if you don't have kids, you have siblings, you have whatever, people can relate to it. So just really sad details here. We're going to take a quick break, but court is expected to get back underway any minute. In fact, the defendant is in court, the judge is in there, so stay with us. We will be right back after this. We'll take you live to Ohio. Stay with us. Well, that is Dr. Patty Van Eye. She's the clinical director of a foster care organization. And wow, Michael, pretty impressive witness there, listing off her credentials and all the work she's done with children who have experienced trauma, abuse, sexual abuse. She just talked about working with the whole family and understanding the multi-generational aspect of family violence. So she seems to be, thus far at least, a very credible and impressive witness. And I assume she will be talking about the defendant's, trauma and brain scans.
Well, she's still doing her CV, so it's been going on for a while.
She's been 15 minutes in almost.
She has a really nice demeanor. She has she comes across as a kind witness. She's dedicated a lot of her time to children, etc. And I think her conclusions are going to be such that it's going to be, I think, very persuasive with the jury as far as those credentials and just the care and the experience.
Well, those credentials continue, as you say. We're going to take a quick break. When we come back, much more from her testimony live out of Ohio. Stick around. All right, welcome back. We still have our expert witness here talking about childhood development, brain trauma, how it all comes together. Michael Bachner, our guest in studio, he's going to be leaving us in a few minutes. Michael, your final thoughts on this. First, before I get your final thoughts, actually, is this unusual at all to you how long this presentation is? We were talking about it, during the break. It feels like we're in a college course here. She's literally running through the entire background of infant adult attachment, how bonds form, and so on and so forth. Is it unusual for a witness to just give a totally long presentation like this? We haven't heard that much specifically about the defendant yet, or about her interaction with the defendant. Yeah,
it is a little unusual. She's just trying to really lay that foundation so when she comes to a conclusion, the jury understands why she's reaching it. The problem with her testimony, I think, is going to be ultimately that everybody is fashioned by their experiences. We all know that, and everyone who has a good experience may, ultimately do something wrong, but not everyone who has a bad experience does something wrong. So I'm sure that's kind of the cross that she's going to be expecting.
Yeah, that's the bottom line with all of these cases when they try to prove mitigation. Do you think that some of the jurors have tuned out? I mean, when you hear, it's like you think back to school and you start doodling and you start, fidgeting.
I think some of the synapses have stopped firing in some of the jurors.
Exactly. It is interesting. We will have to see. Your final thoughts on whether the defense will be able to save Anthony Kirkland from the death penalty this time around?
My feeling is that 3 strikes and he's out.
Yeah.
The crime is too horrific. The circumstances are too horrific, and I think I don't think there's much surprise that 2 juries before that had concluded that the death penalty was appropriate. Yeah. Well,
thank you so much for your analysis, as always, today, Michael. It's been great having you. For now, we're going to go back live into that Ohio courtroom as this presentation continues.